Welcome to this comprehensive review of the All India Bar Examination Question Paper Set A. I will guide you through each question, providing a detailed analysis of the correct answer and the underlying legal principles. Pay close attention. Let's begin.
Alright, let's begin with question number 1. If a bailiff executes an eviction based on a civil court order, later declared void for lack of jurisdiction, what protection does Section 78 of the Indian Penal Code provide? A. The bailiff is punishable as the order was invalid from the beginning. B. The bailiff can be punished only with a reduced penalty. C. The bailiff is exempt if he acted in good faith under the order. D. The bailiff is required to compensate the evicted person. Now think about that for a moment. What is the core principle protecting officials acting under court orders? The correct answer is C. Let's break this down. Section 78 provides a crucial safeguard. It establishes that an act done in pursuance of a court's judgment or order is not an offense, even if the court lacked jurisdiction. The absolute key here is the condition of good faith. The person executing the order must believe the court had the necessary authority. Therefore, the bailiff is exempt from liability. Now for question number 2. Under the BNS, what is the maximum number of consecutive days an offender may be kept in solitary confinement at a time? A. 7, B. 10, C. 14, D. 21. This is a direct question about a statutory limit. The correct option is C. The reasoning is straightforward and comes directly from the statute. Section 12 of the Bharatiya Nyaya Samhita 2023 explicitly mandates that when a sentence of solitary confinement is being executed, it shall in no case exceed 14 days at a time. It is a clear and absolute limit. Let's examine question number 3. According to the Motor Vehicles Act 1988, what is the fixed amount of compensation payable in the event of death caused by a motor vehicle accident under no-fault liability? A. 25,000 rupees, B. 50,000 rupees, C. 1 lakh rupees, D. 75,000 rupees. Now, I want you to pay very close attention here, as this highlights a potential issue you might encounter in an exam. This question is in fact flawed, and it's crucial to know why. Let me explain. The principle of no-fault liability is governed by Section 164, subsection 1 of the Motor Vehicles Act 1988. The current, correct fixed compensation payable for death under this provision is a sum of 5 lakh rupees. You will notice this amount is not listed in any of the options. This is a vital reminder to always be updated with the latest statutory amendments and figures. Moving on to question number 4. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A. An employee can be deemed to be in continuous service for 1 year only if he has worked for 365 days in the preceding 12 months without any interruption. Reason R. Under the Payment of Gratuity Act 1972, continuous service may also include periods of interruption due to sickness, accident, leave, layoff, strike or lockout not caused by the employee's fault. In the context of the above assertion and reason under the Payment of Gratuity Act 1972, which one of the following is correct? A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true but R is not the correct explanation of A. C. A is true but R is false. D. A is false but R is true. Analyze both statements carefully. Is the assertion factually correct in the context of labor law? The correct answer is D. Let's dissect this. Assertion A is false. The concept of continuous service in labor jurisprudence does not require 365 days of uninterrupted work. For instance, under Section 25B of the Industrial Disputes Act 1947, working for 240 days is often deemed sufficient. This leads us to reason R, which is true. Labor laws explicitly define continuous service to include periods of interruption for reasons like sickness, accident, leave, layoff, strike, or lockout not caused by the employee's fault. Therefore, the assertion is false, but the reason is true.
Let's proceed to question number 5. Read the following statements and choose the correct option. Statement 1. Under the Indian Penal Code, if a person harbors an offender who has escaped custody for an offence punishable with imprisonment up to 3 years, he shall be punished with imprisonment up to 7 years. Statement 2. The law provides an exception for harboring or concealing by the husband or wife of the offender. In the context of the above statements, under the Indian Penal Code, which one of the following is correct? A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. Evaluate each statement based on the provisions for harboring offenders. The correct answer is C. Here is my analysis. Statement 1 is demonstrably false. It completely misrepresents the punishment under Section 216 of the Indian Penal Code. The actual punishment is not a flat term, but is proportional, and it can extend up to 1/4 the longest term provided for the original offence. Statement 2, however, is true. Section 216 contains an explicit spousal exception, stating that the provision does not apply when the harboring or concealment is by the husband or wife of the offender. Therefore, only statement 2 is correct.
Now let's take up question number 6. If a person attempts an offence punishable with a maximum of 10 years imprisonment, what is the maximum years of imprisonment that can be imposed under Section 62 of the Bharatiya Nyaya Samhita 2023? A. 5 years, B. 7 years, C. 10 years, D. 3 years. This question tests the general rule for punishing attempts. The correct option is A. The answer lies directly in Section 62 of the Bharatiya Nyaya Samhita 2023. This section provides a general rule for attempts where no express provision is made. It stipulates that the punishment may extend to 1/2 of the longest term of imprisonment provided for that offence. 1/2 of 10 years is, of course, 5 years.
Let us turn to question number 7. A juvenile aged 14 years is brought before the court for an offence not punishable with death or imprisonment for life. Under which provision of the Code of Criminal Procedure 1973 will the case primarily fall? A. Section 27. B. Section 125. C. Section 302. D. Section 482. Consider the special provisions for trying juvenile offenders. The correct answer is A. The key provision here is Section 27 of the Code of Criminal Procedure 1973. This section specifically deals with jurisdiction over juveniles. It stipulates that an offence not punishable with death or life imprisonment committed by a person under 16 may be tried by a chief judicial magistrate or a specially empowered court. The other sections are irrelevant. Section 125 is for maintenance, 302 for murder, and 482 concerns the inherent powers of the High Court. Now let's address question number 8. Under Section 290 subsection 1 of the Bharatiya Nagrik Suraksha Sanhita 2023, within how many days from the date of framing of charge can an accused file an application for plea bargaining? Option A, 15. Option B, 30. Option C, 45. Option D, 60. This is a question about a specific procedural timeline. The correct option is B. This is a direct reading of the law. Section 290 subsection 1 of the Bharatiya Nagrik Suraksha Sanhita 2023 clearly provides the time frame. An accused may file an application for plea bargaining within 30 days from the date the charge is framed. Here is question number 9. Under the Bharatiya Nyaya Sanhita 2023,
If a person is ordered to pay a fine of rupees 4,000 but fails to do so, what is the maximum simple imprisonment the court may impose on the defaulter? A. 1 year. B. 2 months. C. 4 months. D. 6 months. This involves the rules for imprisonment in default of fine payment. The correct answer is B. The relevant provision is Section 8, subsection 5, Clause A of the Bharatiya Nyaya Sanhita 2023. This section lays out a scale for default imprisonment. It dictates that the term shall not exceed 2 months when the fine amount does not exceed 5,000 rupees. Since 4,000 rupees is within this slab, the maximum default term is 2 months. Let's move to question number 10. According to Section 18 of the Bharatiya Nagrik Suraksha Sanhita 2023, what is the minimum period of practice as an advocate required to be considered eligible for appointment as a public prosecutor or additional public prosecutor? A. 3 years. B. 5 years. C. 7 years. D. 10 years. This is a question of eligibility for a key legal position. The correct answer is C. The eligibility criteria are clearly defined. Section 18, subsection 7 of the Bharatiya Nagrik Suraksha Sanhita 2023 specifies that a person shall be eligible for appointment as a public prosecutor or an additional public prosecutor only if they have been in practice as an advocate for not less than 7 years. Now for question number 11. Under the Indian Evidence Act 1872, when can facts that are otherwise irrelevant be considered relevant? A. Only when they prove the guilt of the accused directly. B. Only when they form part of a dying declaration. C. When they are inconsistent with a fact in issue or relevant fact. D. When they are part of an admission made in writing. Think about the doctrine of relevancy and its exceptions. The correct answer is C. This question pertains to the principle often underlying a plea of alibi covered under Section 11 of the Indian Evidence Act 1872. This section creates a special category of relevancy. It states that facts not otherwise relevant become relevant if they are inconsistent with any fact in issue or relevant fact, or if they make the existence of such a fact highly probable or improbable. Let's examine question number 12. What condition must be satisfied for prior evidence to be relevant under Section 33 of the Indian Evidence Act 1872? A. The evidence must have been recorded in the presence of a jury. B. The proceeding was between the same parties or their representatives in interest. C. The evidence must have been published in a government gazette. D. The evidence must have been corroborated by expert opinion. Consider the requirements for admitting testimony from a previous proceeding. The correct option is B. The answer lies in the core requirements of Section 33 of the Indian Evidence Act. For evidence given in a previous judicial proceeding to be relevant subsequently, the primary condition is that the proceeding was between the same parties or their representatives in interest. Additionally, the adverse party must have had the right and opportunity to cross-examine, and the issues must have been substantially the same. Moving on to question number 13. During a court trial, the defense lawyer objects to the admissibility of certain papers produced as evidence. The judge clarifies that only documents categorized as public documents under the Indian Evidence Act 1872 can be accepted without strict proof. Which category of documents would fall under public documents in this context? A. Draft agreements between individuals. B. Personal diaries of government officials. C. Internal notes of a private company. D. Judicial and executive acts of public officials. What is the legal definition of a public document? The correct answer is D. The Indian Evidence Act 1872 provides a clear definition. Public documents are those forming the acts or records of the acts of official bodies, tribunals, and public officers, be they legislative, judicial, or executive. Therefore, judicial and executive acts of public officers fall squarely into this category. The other options are classic examples of private documents. Let's proceed to question number 14. Which condition must be satisfied for things said or done by one conspirator to be admissible against others under the Bharatiya Saksha Adhiniyam 2023? A. The statement must be made after the conspiracy has ended. B. The statement must involve unrelated matters of personal benefit. C. There must be reasonable ground to believe a conspiracy exists. D. There must be proof that each conspirator personally committed the act. Think about the foundational requirement for the rule of conspiracy. The correct answer is C. The principle is detailed in Section 8 of the Bharatiya Saksha Adhiniyam 2023. For the acts or statements of one conspirator to be used against others, a crucial prerequisite must be met. There must be reasonable ground to believe that two or more persons have conspired together. Once this foundation is laid, anything said or done by any of them in reference to their common intention becomes relevant against all. Let's take up question number 15. As per Section 30 of Code of Criminal Procedure 1973, if a magistrate sentenced a person to 2 years imprisonment and a fine, what is the maximum imprisonment he may impose in default of payment of the fine? A. 1 year, B. 2 years, C. 6 months, D. 3 months. This question tests the limits on a magistrate's power to impose a default sentence. The correct option is C. The answer is derived from Section 30, subsection 1, Clause B of the Code of Criminal Procedure 1973. This section limits the default term to 1/4 of the maximum substantive sentence the magistrate is competent to inflict. A magistrate of the first class can impose a sentence up to 3 years. 1/4 of 3 years is 9 months. Of the given choices, 6 months is the maximum possible option that falls within the statutory limit. Now question number 16. As per the Constitution of India after the 86th Constitutional Amendment, which directive principle was modified to ensure early childhood care and education below the age of 6? A. Article 39, B. Article 41, C. Article 47, or D. Article 45. This is a landmark amendment related to education. The correct answer is D. The key here is the Constitution 86th Amendment Act 2002. This amendment significantly altered the landscape of education rights by substituting the original Article 45. The new Article 45 directs the state to endeavor to provide early childhood care and education for all children until they complete the age of 6 years. Let's turn to question number 17. According to the Code of Civil Procedure 1908, who can direct the court that passed the decree to take security when an execution order is challenged in appeal? A. Only the High Court exercising writ jurisdiction. B. The appellate court hearing the appeal. C. The district registrar of property records. D. The police authority of the concerned jurisdiction. Which court has the authority to impose conditions during an appeal? The correct answer is B. The relevant provision is Order 41, Rule 6, Sub-Rule 1 of the Code of Civil Procedure 1908. It clearly states that when a decree under appeal is being executed, the appellate court hearing that appeal has the power to direct the original court to take security from the judgment debtor. This security ensures restitution or performance of the appellate court's final order. Now let's address question number 18. Under the Code of Civil Procedure 1908, how many High Court judges constitute the judicial membership of the Rule Committee? A. 3 judges of the High Court. B. 2 judges of the High Court. C. 4 judges of the High Court. D. 5 judges of the High Court. This is a question about the composition of a specific statutory body. The correct option is A. The composition of the rule committee is explicitly laid out in Section 123, subsection 2, Clause A of the Code of Civil Procedure 1908. It specifies that the committee shall consist of, among others, 3 judges of the High Court where the committee is constituted. Here is question number 19. According to the Copyright Act 1957, what is ordinarily the maximum punishment for copyright infringement under Section 63? A. Imprisonment up to 3 years and fine up to 2 lakh rupees. B. Imprisonment up to 2 years and fine up to 1 lakh rupees. C. Imprisonment up to 5 years and fine up to 3 lakh rupees. D. Imprisonment up to 7 years and fine up to 5 lakh rupees. Recall the penal provisions for copyright violations. The correct answer is A. The punishment for copyright infringement is detailed in Section 63 of the Copyright Act 1957. It provides that a knowing infringer is punishable with imprisonment for a term that may extend to 3 years and with a fine that may extend to 2 lakh rupees. It also sets minimums of 6 months and 50,000 rupees respectively. Let's move to question number 20. As per the Constitution of India, a linguistic community in India seeks to preserve its unique script and literature. Which constitutional provision guarantees them the right to conserve the same? A. Article 28, Clause 1. B. Article 29, Clause 1. C. Article 30, Clause 2. D. Article 32. This question pertains to cultural and educational rights. The correct answer is B. The specific right is enshrined in Article 29, Clause 1 of the Constitution. This fundamental right guarantees that any section of citizens with a distinct language, script or culture shall have the right to conserve it, which is a cornerstone of India's cultural diversity. Now for question number 21. Under Section 58 of the Code of Civil Procedure 1908, what is the maximum period of detention in civil prison for a decree amount exceeding 5,000 rupees? A. 6 weeks. B. 2 months. C. 3 months. D. 6 months. This is about the limits of civil imprisonment for debt. The correct option is C. The answer is found in Section 58, subsection 1, Clause A of the Code of Civil Procedure 1908. It clearly states that where a decree is for payment of a sum exceeding 5,000 rupees, the period of detention shall not exceed 3 months. Let's examine question number 22. Which of the following situations falls within Section 58, 1b of the Code of Civil Procedure 1908? A. Decree for Rs 1800, detention up to 3 months. B. Decree for Rs 3500, detention up to 6 weeks. C. Decree for Rs 6200, detention up to 6 months. D. Decree for Rs 10,000, detention up to 1 year. You need to apply the specific monetary slab mentioned in the section. The correct answer is B. Let's look at the provision. Section 58, subsection 1, Clause B of the CPC deals with the specific range. It permits detention for a period not exceeding 6 weeks if the decree is for a sum exceeding 2,000 rupees but not exceeding 5,000 rupees. A decree for 3,500 rupees fits perfectly within this range, making option B the correct application of the law. Moving on to question number 23. A civil suit is filed against Ajay and the court issues summons requiring him to appear. After receiving the summons, Ajay consults his lawyer to understand the timeline for filing his written statement of defense under the Code of Civil Procedure 1908. Within how many days from the date of service of summons must he submit his written statement? A. 30 days. B. 15 days. C. 60 days. D. 90 days. This is a fundamental procedural deadline in civil litigation. The correct answer is A. The rule is unambiguous. Order 8, Rule 1 of the Code of Civil Procedure 1908 mandates that the defendant shall, within 30 days from the date of service of summons, present a written statement. While extensions are possible, the initial mandatory period is 30 days. Let us proceed to question number 24. How long does the registered address furnished under Section 14A1 of the Code of Civil Procedure 1908 remain valid if not changed? A. 6 years after final determination of the cause. B. 3 years after the institution of the suit. C. 2 years after final determination of the cause. D. 5 years from the date of decree. Consider the duration for which a registered address remains legally effective post-litigation. The correct option is C. The provision governing this is Order 7, Rule 14A, Sub-Rule 3 of the Code of Civil Procedure 1908, which specifies that the registered address furnished by a party shall hold good for a period of 2 years after the final determination of the cause or matter, unless duly changed. Let's take up question number 25. According to Section 25 Clause A of the Arbitration and Conciliation Act 1996, what happens if the claimant fails to submit his statement of claim without sufficient cause? Adjournment indefinitely, penalty but continues proceedings, assumption of admission, or termination of proceedings. What is the consequence of a claimant's default in arbitration? The correct answer is D. The law is very clear on this point. Section 25 Clause A of the Arbitration and Conciliation Act 1996 stipulates that if the claimant, without sufficient cause, fails to communicate his statement of claim, the arbitral tribunal shall terminate the proceedings. It is a decisive consequence. Now, question number 26. If a case is transmitted to the central government under Section 10 of the Special Marriage Act 1954, what is the time limit for solemnizing the marriage after its decision? A. 1 month, B. 2 months, C. 6 months, D. 3 months. This question concerns the validity period of a marriage notice after a decision. The correct answer is D. The answer is found in Section 14 of the Special Marriage Act 1954. This section states that if a marriage is not solemnized within 3 calendar months from the date of the central government's decision, the notice and all related proceedings are deemed to have lapsed. A new notice would then be required. Let's turn to question number 27. What is the maximum term of imprisonment prescribed under Section 31 of the Protection of Women from Domestic Violence Act 2005 for breach of protection order? A. 6 months, B. 1 year, C. 2 years, D. 3 years. This is about the penal consequence of violating a court's protection order. The correct option is B. The punishment is explicitly mentioned in the Act. Section 31, subsection 1 of the Protection of Women from Domestic Violence Act 2005 makes the breach of a protection order a punishable offence. The punishment prescribed is imprisonment for a term which may extend to 1 year or a fine up to 20,000 rupees or both. Now let's address question number 28. Under which provision of the Indian Constitution can a public interest litigation (PIL) be filed directly in the Supreme Court? Article 21, Article 32, Article 226. D. Article 14. Which article grants the Supreme Court its original writ jurisdiction for fundamental rights? The correct answer is B. The power to file a PIL directly in the Supreme Court stems from Article 32 of the Constitution. It guarantees the right to move the Supreme Court for the enforcement of fundamental rights. This is the very heart of the Supreme Court's role as the protector of those rights and the basis for its PIL jurisdiction. Article 226 provides similar, though wider powers to the High Courts. Here is question number 29. Under the Land Acquisition Act 1894, What is the minimum period that must have elapsed between the publication of notice and the appearance of persons interested before the collector? Option A, not less than 7 days. Option B, not less than 60 days. Option C, not less than 15 days. Option D, not less than 30 days. This question asks about a specific notice period in land acquisition proceedings. The correct answer is D. To answer this correctly, you must be aware of an important legislative change. The old Land Acquisition Act 1894 was repealed and superseded by the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Under the new Act, specifically Section 21, subsection 2, the notice must specify a time for appearance not less than 30 days after publication. Let's move to question number 30. Under which provision can a citizen file a public case in the Court of Magistrate regarding issues of public interest? A. Section 302 of the Indian Penal Code. B. Section 144 of Code of Criminal Procedure 1973. C. Section 133 of Code of Criminal Procedure 1973. D. Section 482 of Code of Criminal Procedure 1973. Which section deals with the removal of public nuisances by a magistrate? The correct option is C. The correct provision for this is Section 133 of the Code of Criminal Procedure 1973. This section empowers a magistrate to issue conditional orders for the removal of public nuisances. It is a powerful tool for citizens to address local issues of public interest directly through the magistrate's court. The corresponding provision in the new law is Section 152 of the Bharatiya Nagrik Suraksha Sanhita 2023. Now for question number 31. According to Section 44 AA2I of the Income Tax Act 1961, a person carrying on business must maintain books of account if income from business or profession exceeds A. 1,20,000, B. 50,000, C. 5 lakh rupees, D. 10 lakh rupees. This is a question about the threshold for mandatory accounting under tax law. The correct answer is A. The answer is specified in the Income Tax Act itself. Section 44 AA, subsection 2, clause I, lays down the monetary threshold. It states that a person carrying on a business must maintain books of account if their income exceeds 1,20,000 rupees in any of the 3 immediately preceding years. Let's examine question number 32. Under the Patents Act 1970, which situation prevents a patent application from being published even after the expiry of the prescribed period? A. When the applicant has filed a request for early examination. B. When secrecy direction is imposed under Section 35. C. When the patent has already been granted by the controller. D. When the applicant has requested for an extension of time. Think about exceptions to the general rule of publication, particularly those related to national security. The correct answer is B. The Patents Act has specific provisions for this. Section 11A, subsection 3, clause A, clearly states that an application shall not be published if a secrecy direction is imposed under Section 35. Furthermore, subsection 4 mandates that publication will only occur after the secrecy direction ceases to operate. Moving on to question number 33. Given below are 2 statements, one labeled as assertion A and the other labeled as reason R. Assertion A. Any person having an interest in a newspaper declared forfeited may apply to the High Court to set aside the declaration within 2 months of its publication in the official gazette. Reason R. The special bench of the High Court, to hear such applications, must always consist of exactly 3 judges, regardless of the strength of that High Court. In the context of the above assertion and reason under the Code of Criminal Procedure 1973, which one is correct? A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. Evaluate both the timeline for the application and the composition of the bench. The correct answer is C. Let's analyze this. Assertion A is true. It accurately reflects Section 96, subsection 1 of the CRPC, which sets a 2-month deadline. Reason R, however, is false. While the special bench typically has 3 judges, Section 96, subsection 2 provides an exception. If a High Court has fewer than 3 judges, the special bench shall be composed of all the judges of that High Court. The word always makes the reason incorrect. Let's proceed to question number 34. Read the following statements and choose the correct option. Statement 1. Under the Bharatiya Sakshya Adhiniyam 2023, admissions are generally relevant and may be proved against the person making them, but cannot be ordinarily be proved by or on behalf of that person. Statement 2. An admission can still be proved on behalf of the person making it if it relates to the existence of a state of mind or body made at or about the time when such condition existed and is supported by conduct showing its truthfulness. In the context of the above statements under the Bharatiya Sakshya Adhiniyam 2023, which one of the following is correct? A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. This question tests the general rule of admissions and its specific exceptions. The correct option is D. Both statements are correct and represent the complete legal position. Statement 1 accurately states the general rule found in Section 19 of the Bharatiya Sakshya Adhiniyam 2023. Admissions are used against the maker. Statement 2 correctly describes a critical exception found in Section 19, subsection 2. It allows an admission to be proved on behalf of the maker under those specific circumstances. Thus, both statements are true. Let's take up question number 35. Which type of allowance qualifies for deduction under Section 16(2) of the Income Tax Act 1961? House rent allowance granted by private companies? Entertainment allowance granted to government employees? Transport allowance provided to all salaried persons? Leave travel allowance given for domestic travel? This is about a specific deduction available under the head salaries. The correct answer is B. The provision is very specific. Section 16, Clause 2 of the Income Tax Act provides for a deduction for an entertainment allowance, but it is specifically limited to government employees. The deduction is also capped at the lower of 1/5 of the salary or 5,000 rupees. Now, question number 36. Read the given statements and choose the correct option. Statement 1. Under the Negotiable Instruments Act 1881, a negotiable instrument made, drawn, accepted or transferred without consideration creates no obligation of payment between the parties to the transaction. Statement 2. According to the same Act, if the consideration for which a negotiable instrument was issued fails in part, the holder in immediate relation is entitled to recover only the proportionate amount corresponding to the consideration actually received. In the context of the above statements under the Negotiable Instruments Act 1881, which one of the following is correct? A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. Consider the role of consideration in negotiable instruments. The correct option is D. Both statements accurately reflect the provisions of the Act. Statement 1 is supported by Section 43 of the Negotiable Instruments Act 1881. Statement 2 is supported by Section 44, which addresses partial failure of consideration and allows for a proportionate reduction in the recoverable amount between immediate parties. Therefore, both statements are true. Let's turn to question number 37. In the following question, a statement is followed by 2 conclusions, 1 and 2. Statement. Under the Environment Protection Act 1986, when an offence is committed by a company, every person who was directly in charge of and responsible to the company at the time of the offence, as well as the company itself, is deemed guilty. However, a person may escape liability if he proves that the offense was committed without his knowledge or that he exercised due diligence to prevent it. Conclusions. 1. A company as well as its responsible officers may be held liable for environmental offences under the Act. 2. An officer of a company can never escape liability once the company is found guilty of an offence. In the context of the above statement and conclusions, under the Environment Protection Act 1986, which one of the following is correct? A. Only conclusion 1 follows. B. Only conclusion 2 follows. C. Both conclusions 1 and 2 follow. D. Neither conclusion 1 nor 2 follows. Analyze the statement paying close attention to both liability and the available defenses. The correct answer is A. Let's analyze the conclusions. Conclusion 1 is correct. The statement explicitly says both the company and responsible officers are deemed guilty, reflecting Section 15(f)(2). Conclusion 2, however, is false. The statement itself provides the defense: an officer can escape liability by proving lack of knowledge or due diligence to prevent it. The word never makes it incorrect. Therefore, only conclusion 1 follows. Now, let's address question number 38. Under Section 24A of the Income Tax Act 1961, what percentage of the annual value of an income from house property is allowed as a standard deduction? A. 20, B. 40, C. 30, D. 50. This is a standard calculation in determining taxable income from property. The correct answer is C. The provision is direct and clear. Section 24 Clause A of the Income Tax Act allows for a standard deduction when computing income from house property. The amount of this deduction is a flat 30% of the annual value.
Here is question number 39. After a government notification is issued for acquiring Mr. Mehta's farmland under the Land Acquisition Act 1894, he notices that the income from his crops steadily decreases until the authorities finally take possession. He approaches the court claiming compensation for this reduction in profits. According to the Act, what type of loss is compensable in such a case? A. Loss due to falling land prices in the market. B. Loss due to cancellation of tenant agreements. C. Loss of employment in nearby areas. D. Bona fide diminution of profits due to acquisition process. What kind of damages are considered when calculating compensation for land acquisition? The correct answer is D. Once again, you must refer to the current law, the Right to Fair Compensation Act of 2013. When determining compensation, the collector is required to consider the damage resulting from the bona fide diminution of profits of the land. This covers the period between the declaration and the time of taking possession. Mr. Mehta's loss of income from crops falls directly under this category. Let's move to question number 40. According to Section 35A of the Code of Civil Procedure, 1908, what is the maximum amount a court can award as compensatory costs in ordinary cases? This question is about the monetary limit for costs imposed for frivolous claims. The correct answer is D. The limit for compensatory costs is set by statute. Section 35A, subsection 2 of the CPC mandates that a court shall not award such costs exceeding 3,000 rupees or the limits of its pecuniary jurisdiction, whichever is less. Now for question number 41. According to the Indian Contract Act 1872, when is the communication of an acceptance complete against the proposer? A. When the acceptor prepares the letter of acceptance. B. When it is dispatched beyond the control of the acceptor. C. When it is delivered to the office of the proposer party. D. When the proposer acknowledges receipt in his records. This is a foundational concept in contract law, often called the postal rule. The correct option is B. The rule is explicitly stated in Section 4 of the Indian Contract Act 1872.
It says that the communication of an acceptance is complete as against the proposer the moment it is put into a course of transmission to him so as to be out of the power of the acceptor, for example, when a letter is posted.
Let us examine question number 42. Rahul rents a shop in the city for running his retail business. Later, the landlord decides to terminate the lease. Since the lease is for purposes other than agriculture or manufacturing, and there is no special contract between the parties, the landlord wonders how many days' notice he must legally give under the Transfer of Property Act 1882 to end the lease. What is the required notice period? A. 5 days notice. B. 15 days notice. C. 45 days notice. D. 60 days notice. This question deals with the default notice period for terminating a lease. The correct answer is B. The answer is found in Section 106, subsection 1 of the Transfer of Property Act 1882. In the absence of a contract to the contrary, a lease of immovable property for purposes other than agriculture or manufacturing is deemed a month-to-month lease, terminable by 15 days' notice.
Moving on to question number 43. According to the Negotiable Instruments Act 1881, what is the maximum sentence of imprisonment that a magistrate may pass in a summary trial under Section 143? A. 6 months imprisonment. B. 2 years imprisonment. C. 1 year imprisonment. D. 3 years imprisonment. This is about the sentencing power of a magistrate in a specific type of trial. The correct answer is C. The power of the magistrate is clearly defined. Section 143, subsection 1 of the Negotiable Instruments Act, which deals with summary trials, explicitly permits a magistrate to pass a sentence of imprisonment for a term not exceeding 1 year.
Let's proceed to question number 44. In the following question, a statement is followed by two conclusions, 1 and 2. Statement. As per Section 157 of the Companies Act 2013, every company must, within 15 days of receiving intimation under Section 156, furnish the Director Identification Number (DIN) of all its directors to the registrar with prescribed fees. Failure to comply attracts penalties. Conclusions. 1. If a company fails to furnish the DIN, it can be penalized. 2. Every officer of the company in default is also liable for penalties. In the context of the above statement and conclusions, which one of the following is correct? A. Only conclusion 1 follows. B. Only conclusion 2 follows. C. Both conclusions 1 and 2 follow. D. Neither conclusion 1 nor 2 follows. Analyze the scope of liability for non-compliance. Does it extend beyond the company itself? The correct option is C. Let's examine the relevant section. Section 157, subsection 2 explicitly lays out the consequences for failure. It states that if a company fails to comply, both the company and every officer of the company in default are liable to a penalty. Therefore, both conclusions are correct. Let's take up question number 45. Read the following statements related to the Information Technology Act 2000 and choose the correct option. Statement 1. Under the Information Technology Act 2000, a digital signature certificate may be suspended by the certifying authority on the request of the subscriber, an authorized representative, or if it is considered necessary in the public interest. Statement 2. Under the same Act, a digital signature certificate can remain suspended indefinitely without providing the subscriber an opportunity of being heard. A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. Evaluate the grounds for suspension and the procedural safeguards involved. The correct answer is B. Here's the breakdown. Statement 1 is true. It accurately reflects the grounds for suspension in Section 37, subsection 1 of the IT Act. Statement 2, however, is false. Section 37, subsection 2 provides a crucial safeguard. A certificate cannot be suspended for more than 15 days unless the subscriber has been given an opportunity of being heard. Thus, only statement 1 is true. Now, question number 46. In the following question, a statement is followed by two conclusions, 1 and 2. Statement.
According to the Child and Adolescent Labor Prohibition and Regulation Act 1986, the appropriate government credits Rs 15,000 to the Child and Adolescent Labor Rehabilitation Fund for each child or adolescent for whom the fine amount from the employer has been deposited. The amount in the fund is deposited or invested in banks, and the interest accrued is also payable to the child or adolescent. Conclusions: 1. The child or adolescent is entitled not only to the credited amount but also to the interest accrued on it. 2. The government is not required to deposit any money other than what is collected as fines from the employer. In the context of the above statement and conclusions, which one of the following is correct? A. Only conclusion 1 follows. B. Only conclusion 2 follows. C. Both conclusions 1 and 2 follows. D. Neither conclusion 1 nor 2 follows. Read the statement carefully, noting where the funds come from and who receives the benefits. The correct answer is A. Let's analyze. Conclusion 1 is correct. Section 14B(4) of the Act provides that the amount deposited and the interest accrued shall be paid to the child. Conclusion 2 is incorrect. Section 14B(2) requires the government to deposit 15,000 rupees in addition to the fine. The conclusion that the government deposits only the fine amount is therefore false. Only conclusion 1 follows. Let's turn to question number 47. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A, the Bharatiya Nyaya Sanhita 2023 prescribes the death penalty for certain forms of gang rape. Reason R, the purpose of this provision is to make all sexual offences non-bailable. In the context of the above assertion and reason, which one of the following is correct? A, both A and R are true and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. Examine the assertion about the penalty and the reason regarding the bailability of offences. The correct option is C. Let's break it down. Assertion A is true. Section 72 of the BNS does prescribe the death penalty for gang rape of a woman under 18. Reason R, however, is false. While gang rape is non-bailable, the purpose of this specific penalty is deterrence, not to make all sexual offences non-bailable. Other sexual offences in the Sanhita, such as under Section 67, are bailable. Now, let's address question number 48. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A. Under the Bharatiya Nagrik Suraksha Sanhita 2023, if the proclaimed person appears within the time specified in the proclamation, the court shall release the attached property. Reason R. The attachment of property under the Bharatiya Nagrik Suraksha Sanhita 2023 is intended to compel the appearance of the proclaimed person before the court, not to permanently deprive him of his property. In the context of the above assertion and reason, which one of the following is correct? A. Both A and R are true and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. Consider the purpose of property attachment in criminal procedure. The correct answer is A. This is a classic example of a correct assertion and its explanation. Assertion A is true, reflecting Section 88 of the BNSS. Reason R is also true and perfectly explains why the assertion is true. Attachment is a coercive measure to compel appearance, not a permanent forfeiture. The property is released upon appearance because the purpose has been served. Thus, R is the correct explanation of A. Here is question number 49. Read the given statements and choose the correct option. A dispute arises between two companies regarding the enforcement of their arbitration clause. Examine the following statements. Statement 1. An arbitration agreement must be in writing and it can be contained in a contract, an exchange of letters, telex, telegrams, or electronic communications. Statement 2. An arbitration agreement may be implied solely from the conduct of the parties without any written record. A. Only statement 1 is true. B. Only statement 2 is true. C. Both statements 1 and 2 are true. D. Neither statement 1 nor 2 is true. What is the fundamental requirement for a valid arbitration agreement? The correct answer is A. Let's analyze. Statement 1 is true. Section 7 subsection 3 of the Arbitration and Conciliation Act mandates that the agreement must be in writing, and Section 7 subsection 4 includes various forms of communication. Statement 2 is false. The act is unequivocal. The agreement must be in writing. It cannot be implied solely from the conduct without a written record. Therefore, only statement 1 is true.
Let's move to question number 50. In the following question, a statement is followed by two conclusions, 1 and 2. Statement: according to the Advocates Act 1961, when the term of a state bar council expires without an election, the Bar Council of India shall constitute a special committee consisting of the ex-officio member of the State Bar Council as chairman and two nominated members. The special committee has the power to discharge all functions of the State Bar Council until the new council is constituted, and elections must be held within 6 months unless the period is extended by the Bar Council of India. Conclusions: 1. The special committee is empowered to handle pending disciplinary matters of the State Bar Council. 2. The Bar Council of India may extend the 6-month period for holding elections to the State Bar Council for recorded reasons. In the context of the above statement and conclusions, which one of the following is correct? Option A. Only conclusion 1 follows. Option B. Only conclusion 2 follows. Option C. Both conclusions 1 and 2 follow. Option D. Neither conclusion 1 nor 2 follows. Evaluate the powers of the special committee and the BCI based on the statement. The correct option is C. The statement describes the provisions of Section 8A of the Advocates Act. Let's check the conclusions. Conclusion 1 is correct. The committee discharges all functions, and Section 8A 2C explicitly transfers all pending proceedings, including disciplinary matters. Conclusion 2 is also correct. Section 8A 3 allows the BCI to extend the 6-month election period provided reasons are recorded in writing. Therefore, both conclusions logically follow. Now for question number 51. Read the given statements and choose the correct option. Statement 1. Under the Income Tax Act 1961, a deduction equal to 30% of the annual value is allowed while computing income from house property. Statement 2. Where the property has been acquired or constructed with borrowed capital, the maximum deduction for interest payable on such capital is capped at Rs 2 lakhs subject to conditions. A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. This question tests knowledge of two key deductions related to house property. The correct answer is D. Both statements are factually correct. Statement 1 is true as per Section 24A of the Income Tax Act, which allows the flat 30% standard deduction. Statement 2 is also true as the second proviso to Section 24 specifies that the maximum deduction for interest on borrowed capital for a self-occupied property shall not exceed Rs 2 lakh subject to conditions. Let's examine question number 52. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A.
Under the Hindu Succession Act 1956, a daughter in a joint Hindu family governed by Mitakshara law becomes a co-partner by birth in her own right, just like a son. Reason R. This provision grants daughters the same rights, liabilities and disabilities in co-partnery property as those of sons. In the context of the above assertion and reason, under the Hindu Succession Act 1956, which one of the following is correct? A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true but R is false. D. A is false but R is true. This is about a landmark amendment in Hindu succession law. The correct answer is A. Assertion A is correct. This is the essence of the 2005 amendment codified in Section 6(1)(a) of the Hindu Succession Act. Reason R is also correct and directly explains the consequence of the assertion. Clauses B and C of Section 6(1) explicitly grant her the same rights and liabilities as a son. Therefore, R is the correct explanation for A. Moving on to question number 53. As per the Indian Contract Act 1872, an acceptance must be absolute and unqualified. What is the legal effect if an offeree's response to a proposal introduces a new term? A. It becomes a valid acceptance and the new term is incorporated as a mere suggestion. B. It operates as a valid acceptance if the new term is not a material alteration. C. It constitutes a counter-proposal, thereby rejecting the original proposal. D. It suspends the original proposal until the new term is accepted or rejected by the proposer. Think about the mirror image rule in contract formation. The correct answer is C. The principle is fundamental to contract law and is found in Section 7(1) of the Indian Contract Act. An acceptance must be absolute and unqualified. If the response varies the terms, it is not an acceptance. Instead, it operates as a counter-proposal, which has the legal effect of rejecting the original proposal.
Let's proceed to question number 54. The Indian Contract Act 1872 provides for specific situations where an agreement without consideration is not void. Which of the following agreements is valid despite the lack of fresh consideration? A. An oral promise by A to pay B Rs 5,000 for a service B voluntarily rendered to A last month. B. A written and registered promise by a husband out of natural love and affection to transfer a property to his wife. C. A promise to subscribe Rs 1 lakh to a public charitable fund. D. A promise made by a minor upon attaining majority to pay a debt incurred during his minority. Which of these scenarios fits a statutory exception to the no consideration, no contract rule? The correct option is B. The general rule is that an agreement without consideration is void. However, Section 25(1) of the Indian Contract Act validates an agreement if it is in writing, registered, and made on account of natural love and affection between parties in a near relation. Option B perfectly fits all these criteria. Let's take up question number 55. In the context of delegated legislation, the judicial doctrine that prevents a legislature from conferring uncontrolled legislative power on the administration is known as the doctrine of A. Ultra vires, B. Excessive delegation, C. Conditional legislation, D. Separation of powers. This is a core concept in administrative law that checks the legislature's power to delegate. The correct answer is B. The correct term is the doctrine of excessive delegation. While a legislature can delegate power to fill in the details, it cannot abdicate its essential legislative function. If it confers law-making power without providing a clear policy or framework, it is an excessive or unconstitutional delegation of its power.
Now, question number 56. For a petition for nullity of marriage under the Hindu Marriage Act 1955 on the ground that consent was obtained by fraud, what is a statutory bar to granting the decree? A. The petition was filed more than 6 months after the discovery of the fraud. B. The petitioner has lived with the respondent as husband and wife after the discovery of the fraud. C. The fraud relates to the social status of the respondent's family. D. The parties have not attempted reconciliation through a counseling center. What action by the petitioner condones the fraud and bars the remedy? The correct answer is B. The Hindu Marriage Act provides a specific bar. According to Section 12(2)(a) II, a petition for annulment on the ground of fraud shall not be entertained if the petitioner has, with their full consent, lived with the other party as husband or wife after the fraud had been discovered. This act is treated as condonation.
Let's turn to question number 57. In the absence of an agreement between the parties, the arbitration proceedings are said to have commenced under Section 21 of the Arbitration and Conciliation Act 1996. A. On the date of appointment of arbitrator. B. On the date the arbitration agreement is signed. C. On the date the request for reference is received by the respondent. D. On the date the arbitral tribunal issues notice. What event triggers the official commencement of arbitration proceedings? The correct option is C. The Act provides a clear default rule. Section 21 of the Arbitration and Conciliation Act 1996 states that unless otherwise agreed, arbitral proceedings commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. This date is crucial for limitation purposes.
Now let's address question number 58. Which of the following public interest litigations expanded Article 21 of the Indian Constitution to include right to enjoyment of pollution-free water and air? The answer is A. Subhash Kumar vs. State of Bihar, 1991 SCC 598, the case that explicitly expanded the right to life under Article 21 to include the right to a healthy environment, is Subhash Kumar vs. State of Bihar. The Supreme Court held that the right to life includes the right to enjoy pollution-free water and air for the full enjoyment of life, empowering citizens to invoke Article 32 to address environmental degradation. Here is question number 59. Which public interest litigation case resulted in the Supreme Court of India laying down the principle of absolute liability? A. MC Mehta vs. Union of India, AIR 1987 SC 1086. B. MC Mehta vs. Union of India, 1988 SCR 230. C. MC Mehta vs. Kamal Nath, 1997 1 SCC 388. D. MC Mehta vs. Union of India, AIR 1997 SC 734. Which case arising from the oleum gas leak established this stringent liability principle? The correct answer is A. The principle of absolute liability was evolved by the Supreme Court of India in the case of MC Mehta vs. Union of India, reported in AIR 1987 Supreme Court 1086, famously known as the oleum gas leak case. The court held that an enterprise engaged in a hazardous activity is absolutely liable to compensate all those affected by an accident without any of the exceptions available under strict liability.
Let's move to question number 60. In which of the following cases the Supreme Court of India has pointed out that the rule of nemo judice in quasi sua is subject to the doctrine of necessity? Sahni Silk Mills P. Ltd. vs. Employee State Insurance Corporation, 1994, 5 SCC 346. In Re. Delhi Laws Act, Air India, 1951, SC 332. J. Mahapatra and Company vs. State of Orissa, 1984, 4 SCC 103. Union of India vs. G. Ganayatham, 1997, 7 SCC 463. This question is about an important exception to the rule against bias. The correct option is C. The Supreme Court discussed the interplay between the rule against bias and the doctrine of necessity in J. Mahapatra and Company vs. State of Orissa.
the court affirmed the rule of nemo judix in causa sua, no one should be a judge in their own cause, but explained that the doctrine of necessity provides an exception when a biased adjudicator must hear a case because no other competent authority is available, thus preventing a failure of justice. Now, for question 61. As per Section 11 of the Code of Civil Procedure 1908, for res judicator to be applicable on a subsequent suit, the former suit 1. has been finally decided, 2. can only be instituted prior to the subsequent suit, 3. relates to the same matter directly and substantially in issue in the subsequent suit, 4. is between the same parties or between parties under whom they or any of them claim. Select the correct answer. A. 1, 2 and 3, B. 2, 3 and 4, C. 1, 3 and 4, D. 1, 2, 3 and 4. Recall the essential elements for the doctrine of res judicator to apply. The correct answer is C. Let's evaluate the conditions based on Section 11 of the CPC. Condition 1, final decision, is correct. Condition 3, same matter in issue, is correct. Condition 4, same parties, is correct. Condition 2, however, is incorrect. Explanation 1 to Section 11 clarifies that the former suit is one that was decided prior, regardless of when it was instituted. Therefore, the correct combination is 1, 3 and 4. Let's examine question number 62, where the decree is for the payment of money. Execution by detention in prison shall not be ordered unless after giving the judgment debtor an opportunity of showing cause, the court is satisfied that the 1. judgment debtor is likely to abscond or leave the local limits of the jurisdiction of the court. 2. Judgment debtor has, before the institution of the suit in which the decree was passed, dishonestly transferred any part of his property. 3. Decree is for a sum for which the judgment debtor was bound in a fiduciary capacity to account. 4. Judgment debtor has or has had since the date of the decree the means to pay substantial amount of the decree and neglected to pay the same. Select the correct answer. A. 1, 2 and 3, B. 2, 3 and 4, C. 1, 3 and 4, D. 1, 2, 3 and 4. Carefully check the grounds listed in the CPC for ordering civil imprisonment. The correct option is C. The grounds for detention are in the proviso to Section 51 of the CPC. Condition 1, likely to abscond, is correct. Condition 3, fiduciary capacity, is correct. Condition 4, means to pay but refuses, is also correct. Condition 2 is incorrect. The statute refers to dishonest transfer after the institution of the suit, not before the institution of the suit. Therefore, the correct grounds are 1, 3 and 4. Moving on to question number 63. As per the Code of Civil Procedure 1908, a decree ex parte can be set aside against a defendant 1. if he satisfies the court that the summons was not duly served, 2. if he satisfies the court that he was prevented by any sufficient cause from appearing when the suit was called on for hearing, 3. if he satisfies the court that there has been an irregularity in the service of summons despite the fact that defendant had notice of the date of hearing and had sufficient time to appear and answer the plaintiff's claim, 4. without notice being served on the opposite party. Select the correct answer. A. 1 and 2, B. 1, 2 and 3, C. 1 and 4, D. 1, 2, 3 and 4. What are the valid grounds for setting aside an ex parte decree? The correct answer is A. The grounds are in Order 9, Rule 13. Condition 1, summons not duly served is a valid ground. Condition 2, prevented by sufficient cause is also a valid ground. Condition 3 is incorrect. The second proviso to Rule 13 states a decree cannot be set aside for mere irregularity in service if the defendant had notice of the date of hearing. Condition 4 is also incorrect. Rule 14 requires notice of the application to be served on the opposite party. Thus, only 1 and 2 are correct. Let's proceed to question number 64. When is a confession made by a person in police custody admissible under the Bharatiya Saksha Adhiniyam 2023? A. Only if it is made voluntarily in writing. B. Only if it is made in the immediate presence of a magistrate. C. Only if it is supported by 2 independent witnesses. D. Only if it is recorded after the charge sheet is filed. What is the crucial exception to the rule against confessions in police custody? The correct answer is B. The general rule is that a confession in police custody is inadmissible. However, Section 23(2) of the Bharatiya Sakshya Adhiniyam provides the vital exception: a confession shall not be proved against the accused unless it is made in the immediate presence of a magistrate. This judicial supervision is the safeguard that makes it admissible. Let's take up question number 65. Which section of Bharatiya Sakshya Adhiniyam 2023 pertains to opinions of experts? A. Section 38, B. Section 39, C. Section 36, D. Section 46. This is a direct question about a specific section number. The correct option is B. This is a matter of knowing the statute. Section 39 of the Bharatiya Sakshya Adhiniyam 2023 is the provision that deals with the relevancy of expert opinions. Now, question number 66. Which of the following statements is incorrect as per the Bharatiya Sakshya Adhiniyam 2023? A contracts, in writing, with B for the delivery of indigo upon certain terms. The contract mentions the fact that B had paid A the price of other indigo contracted for verbally on another occasion. Oral evidence is offered that no payment was made for the other indigo. The evidence is admissible. B. A agrees absolutely in writing to pay B 1,000 rupees on 1st March 2023. The fact that, at the same time, an oral agreement was made that the money should not be paid till 31st March 2023 can be proved. C. A enters into a written contract with B to work certain mines, the property of B, upon certain terms. A was induced to do so by a misrepresentation of B as to their value. This fact may be proved. D. A orders goods from B by a letter in which nothing is said as to the time of payment, and accepts the goods on delivery. B sues A for the price. A may show that the goods were supplied on credit for a term still unexpired. This question tests the parole evidence rule and its exceptions. Which scenario violates the rule? The incorrect statement, and therefore the correct answer is B. The core principle here is the parole evidence rule in Section 95 of the Bharatiya Sakshya Adhiniyam 2023. It excludes oral evidence that contradicts a written contract. Statement B is a classic violation. Statement B is a classic violation of the rule. An absolute written promise to pay on a specific date cannot be contradicted by a simultaneous oral agreement to pay later. This is even an illustration to the section. The other options are valid exceptions to the rule. Let's turn to question number 67. As per the Hindu Marriage Act 1955, two persons are said to be within the degrees of prohibited relationship if one is a lineal ascendant of the other, including relationship by adoption. 2. One was the wife or husband of a lineal ascendant or descendant of the other, including relationship by half or uterine blood as well as by full blood. 3. One was the wife of the brother or of the father's or mother's brother or of the grandfather's or grandmother's brother of the other. 4. The two are brother and sister, uncle and niece, aunt and nephew, or children of brother and sister, or of two brothers or of two sisters. Select the correct answer. A. 1, 3 and 4. B. 3 and 4. C. 2, 3 and 4. D. 1, 2, 3 and 4. Consider the complete definition of prohibited relations under the Act. The correct answer is D. The definition in Section 3G of the Hindu Marriage Act is comprehensive. All four statements accurately describe relationships that fall within this definition, covering lineal ascendants, spouses of lineal relations, specific avuncular relationships, and close sibling cousin relationships. The explanation to the section also includes relationships by adoption and half-blood as well as by full blood. Therefore, all four statements are correct. Now let's address question number 68. Which article of the Constitution of India lays down the fundamental duty of every citizen to protect and improve the natural environment? A. Article 48A, B. Article 39A, C. Article 51A G, D. Article 51A H. This is a question about a specific fundamental duty. The correct option is C. The fundamental duties are in Article 51A. Specifically, subclause G states the duty of every citizen to protect and improve the natural environment. Article 48A is a directive principle of state policy which directs the state, not the citizen, to protect the environment. Here is question number 69. The grounds for decree of dissolution of marriage under Section 2 of the Dissolution of Muslim Marriages Act 1939 are that the 1. Whereabouts of the husband have not been known for a period of 2 years. 2. Husband has been sentenced to imprisonment for a period of 5 years. 3. Husband has failed to perform without reasonable cause his marital obligations for a period of 2 years. 4. Husband has neglected or has failed to provide for maintenance of his wife for a period of 1 year. Select the correct answer. This is a classic trick question that tests precise knowledge of statutory time periods. Check each one carefully. The correct answer is D. Let's compare the question with Section 2 of the Act. For ground 1, the period is 4 years, not 2. For ground 2, the sentence must be for 7 years or upwards, not 5 years. For ground 3, the period is 3 years, not 2. And for ground 4, the period is 2 years, not 1. Since all the time periods mentioned are incorrect, none of the statements is true. Let's move to question number 70. As per the Information Technology Act 2000, intermediary with respect to any particular electronic records means any person who, on behalf of another person, receives, stores, or transmits that record or provides any service with respect to that record and includes 1. Telecom service providers, 2. Search engines, 3. Cyber cafes, 4. Online auction sites. Select the correct answer. A. 1 and 4, B. 1 and 2, C. 1, 2 and 4, D. 1, 2, 3 and 4. Consider the broad and inclusive definition of intermediary under the IT Act. The correct answer is D. The definition of intermediary in the Information Technology Act 2000 is extremely wide. It is designed to cover a broad range of entities. The statute explicitly includes telecom service providers, search engines, online auction sites, and cyber cafes in its definition. Therefore, all 4 options are correct examples. Now for question number 71. Under Section 37 of the Arbitration and Conciliation Act 1996, which of the following orders is not appealable? A. Refusing to refer parties to arbitration under Section 8. B. Refusing to appoint arbitrator under Section 11. C. Refusing to grant any measure under Section 9. D. Refusing to grant an interim measure under Section 17. This question tests the specific provisions on appeals in arbitration matters. The correct option is B. The appealability of orders is strictly governed by the Act. While Section 37 lists several appealable orders, a decision by the Supreme Court or High Court under Section 11, which includes refusing to appoint an arbitrator, is designated as final. The section explicitly states that no appeal shall lie against such a decision. Let's examine question number 72. Under Section 9A of the Advocates Act 1961, a legal aid committee constituted by a bar council shall consist of A. Not exceeding 13 but not less than 9 members, B. Not exceeding 11 but not less than 7 members, C. Not exceeding 9 but not less than 5 members, D. Not exceeding 7 but not less than 3 members. This is a question about the specific composition of a bar council committee. The correct answer is C. The answer is found directly in the statute. Section 9A(1) of the Advocates Act provides that a legal aid committee shall consist of a number of members not exceeding 9 but not less than 5. Moving on to question number 73. Which section of the Advocates Act 1961 provides for the disciplinary powers of the Bar Council of India? A. Section 35, B. Section 36, C. Section 37, D. Section 38. Which section grants disciplinary authority to the apex body, the BCI? The correct answer is B. It's important to distinguish the powers. Section 35 deals with the power of state bar councils to punish advocates for misconduct. Section 36, on the other hand, explicitly lays out the disciplinary powers of the Bar Council of India, which includes withdrawing cases from a state bar council. Sections 37 and 38 deal with appeals. Let's proceed to question number 74. Match list 1, general defenses in tort, with list 2, leading cases, and select the correct answer using the codes given below. List 1. 1. Act of God. 2. Consent, volunty non-fit injuria. 3. Statutory authority. 4. Necessity. List 2. 1. Vaughan vs. Taff Vale Rail Company. 2. Kirk vs. Gregory. 3. Nichols vs. Marsland. 4. Hall vs. Brooklands Auto Racing Club. Let's match these foundational tort law concepts with their landmark cases. The correct option is C. Let's go through the matching. Act of God is famously associated with Nichols vs. Marsland, extraordinary rainfall, so I matches 3. Consent is illustrated by Hall vs. Brooklands Auto Racing Club, spectator accepting risks, so IV matches 4. Statutory authority is exemplified in Vaughan vs. Taff Vale Rail Company, sparks from a train, so I3 matches 1. Finally, necessity is linked to Kirk vs. Gregory, so I4 matches 2. This gives us the combination I3, IV4, I31 and IIV2. Let's take up question number 75. The Central Consumer Protection Council, as provided under Section 3 subsection 2 of the Consumer Protection Act 2019, shall consist of a chairperson and 10 other members, or a chairperson and such other members as may be prescribed, a chairperson and 5 other members, a chairperson and such other members as may be prescribed, a chairperson and 10 other members. What does the statute say about the composition of the Central Council? The correct answer is C. The composition is in Section 3 subsection 2 of the Consumer Protection Act 2019. Clause A names the minister in charge as chairperson. Clause B states the council will have such number of other official or non-official members as may be prescribed. It does not fix a number but leaves it to be determined by rules. Now, question number 76. In which of the following cases the Supreme Court of India held that the preamble is not part of the Constitution? A. In Read the Kerala Education Bill 1957. B. Kesavananda Bharati vs. State of Kerala. C. In Read the Berubari Union and Exchange of Enclaves. D. Minerva Mills Limited vs. Union of India. This question pertains to a very important, though later overruled constitutional interpretation. The correct answer is C. The Supreme Court made the specific observation in Re the Berubari Union. The court stated that while the preamble is a key to open the mind of the makers, it is not part of the Constitution. It's crucial to remember that this position was famously overturned later in the Kesavananda Bharati case, where the court held that the preamble is indeed part of the Constitution. Let's turn to question number 77. Which article in the Constitution of India relates to the subject matter of laws made by Parliament to give effect to treaties and international agreements? According to which article gives Parliament overriding power to legislate on international matters? The correct option is C. The power of Parliament in this regard is enshrined in Article 253. This article grants Parliament the power to make any law for India, to implement any treaty or international agreement, notwithstanding the normal distribution of legislative powers between the Union and the states. Now, let's address question number 78. In which of the following judgments was the issue of right to privacy dealt with by the Supreme Court of India? 1. Kharak Singh vs. State of Uttar Pradesh. 2. PUCL vs. Union of India. 3. Justice K.S. Puttaswamy vs. Union of India. 4. MP Sharma vs. Satish Chandra. A. 2, 3 and 4. B. 2 and 3. C. Only 3. D. 1, 2, 3 and 4. Consider the entire jurisprudential journey of the right to privacy in India. The correct answer is D. All four of these cases are significant milestones. In MP Sharma and Kharak Singh, the court held that privacy was not a distinct fundamental right. The PUCL case recognized privacy as a part of Article 21. Finally, the 9-judge bench in Justice K.S. Puttaswamy definitively declared the right to privacy as an intrinsic part of the right to life and personal liberty under Article 21. Therefore, all four cases are relevant.
Here is question number 79. Which of the following actions is required if territory is ceded to any other country by the Union of India? A. Executive action of the Union of India. B. Presidential proclamation exercising constitutional power while issuing proclamation. C. Executive action of the Union of India and then legislative enactment by the Parliament. D. Legislative enactment by the Parliament and then executive action of the Union of India. What is the constitutional procedure for altering the territory of India? The correct answer is D. Ceding national territories is a significant act. First, Parliament must enact a law, often a constitutional amendment under Article 368, to approve the secession. This fulfills the requirement under Articles 3 and 4 and gives effect to the international agreement under Article 253. Only after this legislative enactment can the executive branch take the action of physically transferring the territory. So it is legislative enactment followed by executive action.
Let's move to question number 80. The President has referred a question to the Supreme Court, and the Supreme Court, as per Article 143 of the Constitution of India, has advised the President accordingly. Can the advice given by the Supreme Court be considered as judicial precedent? The answer to question number 80 is option A. The jurisdiction under Article 143 is advisory, not adjudicatory. The court provides an opinion, not a judgment. Article 141 states that the law declared by the Supreme Court is binding. An advisory opinion is not considered law declared in the same binding sense. Therefore, it is not a judicial precedent because it is not a judgment. Now for question number 81. In a criminal trial of defamation, the trial court, that is the High Court, has restrained publication of any news on the given case. Which of the following constitutional powers has been exercised by the High Court while passing given order? A. Power to issue the writ of mandamus. B. Power to issue the writ of prohibition. C. Inherent power. D. Residuary power. Which power allows a court to pass orders to secure the ends of justice? The correct answer is C. The power to issue a gag order to ensure a fair trial stems from the inherent power of the High Court. This power is saved and recognized by provisions like Section 528 of the BNSS or Section 482 of the CRPC. It allows the High Court to make any orders necessary to prevent the abuse of process or to secure the ends of justice. Let's examine question number 82. The Supreme Court of India has declared that right to information is a fundamental right of every citizen of India. Which of the following stated provisions is used as source of the fundamental right given by the Supreme Court? A. Article 19(1), B. Constitution of India. B. Right to Information Act 2005. C. Article 19(1)(a), Constitution of India. D. Article 19(1), Constitution of India and Right to Information Act 2005 collectively. From which fundamental freedom is the right to information derived? The correct answer is C. The Supreme Court has held that the right to information is an intrinsic part of the fundamental right to freedom of speech and expression guaranteed under Article 19(1)A. The logic is that freedom of expression is incomplete without the freedom to seek and receive information. The RTI Act 2005 is the statutory framework that gives effect to this constitutional right.
Moving on to question number 83. Which of the following schedules of the Constitution of India deals with the subject matter of validation of certain acts and regulations? Schedule 9, Schedule 3, Schedule 5, Schedule 10. This is a direct question about the contents of the schedules to the Constitution. The correct option is A. The 9th schedule is the correct answer. It was added by the First Amendment along with Article 31B. Its purpose is to protect the laws listed within it from judicial review on the grounds that they violate fundamental rights. Let's proceed to question number 84. Consider the following statements regarding Article 32 of the Constitution of India. 1. The article is silent about the locus standi, about who may approach the Supreme Court. 2. The article is silent about the opposite party against whom the relief under Article 32 may be granted. 3. The article creates room for even a sixth type of writ within its scope. Select the correct answer. A. 1 is false. B. 2 is false. C. 3 is false. D. All statements are true. Analyze the text and scope of Article 32 carefully. The correct answer is B. Let's evaluate each statement. Statement 1 is true. The concept of locus standi has been liberalized by judicial interpretation. Statement 3 is also true. The article allows for directions, orders, or writs, whichever may be appropriate. However, Statement 2 is false. Article 32 is for enforcing rights under Part 3, which are primarily enforceable against the state as defined in Article 12. Therefore, it is not silent about the opposite party. Let's take up question number 85. By virtue of Articles 129 and 215, the Supreme Court of India and the High Courts in the states are courts of record and possess contempt jurisdiction. What is true about the lower judiciary in the same connection? Lower judiciary has to bear with its contempt. Lower judiciary has to complain about its contempt to the Supreme Court of India. Lower judiciary can itself punish the contemner for having caused its contempt. The respective high courts can take up the matter of such a contempt under whose jurisdiction the lower court falls. How is contempt of a subordinate court dealt with? The correct answer is D. While subordinate courts have limited powers, the broader power to punish for contempt of subordinate courts lies with the High Court. As courts of record under Article 215, High Courts have the power to punish for their own contempt and for the contempt of courts subordinate to them. This power is also reflected in the Contempt of Courts Act 1971. Now question number 86. The Supreme Court of India in R.K. Anand v. Registrar, Delhi High Court, 2009, 8 SCC 106, held an advocate guilty of misconduct for threatening judges and use of abusive language during proceedings, or filing false affidavits and making reckless allegations against judges, or interfering in a criminal trial by attempting to influence a witness, or circulating scandalous pamphlets against a sitting Chief Justice. This question is about a famous case concerning professional ethics. The correct answer is C. In the landmark case of R.K. Anand v. Registrar, Delhi High Court, which arose from the BMW trial, the senior advocate was held guilty of gross professional misconduct for interfering in a criminal trial by attempting to influence a key witness. The Supreme Court heavily condemned this act of trying to suborn a witness. Let's turn to question number 87. Match List 1 with List 2 and select the correct answer using the codes given below. List 1. A. Legitimacy of children of void and voidable marriages. B. Punishment of bigamy. C. Judicial separation. D. Voidable marriages. List 2. 1. Section 10 The Hindu Marriage Act 1955.
2. Section 12, the Hindu Marriage Act 1955. 3. Section 17, the Hindu Marriage Act 1955. 4. Section 16, the Hindu Marriage Act 1955. This requires matching concepts from the Hindu Marriage Act with their correct section numbers. The correct option is C. Let's match them. Legitimacy of children is under Section 16, so A matches 4. Punishment of bigamy is in Section 17, so B matches 3. Judicial separation is governed by Section 10, so C matches 1. And voidable marriages are listed in Section 12, so D matches 2. This gives the sequence 1 4, 2 3, 3 1, 4 2. Now let's address question number 88. Under the Indian Contract Act 1872, what happens if the principal debtor leaves part of the debt unpaid and there are two or more co-sureties? A. The creditor alone bears the unpaid portion of the debt. B. The debtor's family becomes liable for the unpaid amount. C. The co-sureties share the unpaid portion in equal contribution. D. The entire unpaid portion is to be paid by the surety first approached. What is the rule for contribution among co-sureties? The correct answer is C. The principle of contribution is in Section 146 of the Indian Contract Act. It states that where there are two or more co-sureties, they are liable, absent a contract to the contrary, to contribute equally to pay the part of the debt that remains unpaid by the principal debtor. Here is question number 89. Under the Specific Relief Act 1963, when can a defendant in possession of movable property be compelled to deliver it to the plaintiff? A. When the property is held as agent or trustee of the plaintiff. B. When the property is held as mortgage asset of the plaintiff. C. When the property is held as lessee or subtenant of the plaintiff. D. When the property is held as co-owner in common with the plaintiff. In which scenario is specific delivery of movable property compelled? The correct answer is A. The grounds are listed in Section 8 of the Specific Relief Act 1963. One of the specified grounds is when the property is held by the defendant as the agent or trustee of the plaintiff. In such a fiduciary relationship, the court can compel specific delivery. Let's move to question number 90. Read the following statements and choose the correct option. Statement 1. Under the Administrative Tribunals Act 1985, a joint administrative tribunal for two or more states exercises the same jurisdiction, powers and authority as an administrative tribunal for those states. Statement 2. For the purposes of contempt, a tribunal exercises powers similar to those of a high court, and references to High Court in the Contempt of Courts Act 1971 are construed to include such tribunals. In the context of the above statements under the Administrative Tribunals Act 1985, which one of the following is correct? A. Both statements 1 and 2 are false. B. Only statement 1 is true. C. Only statement 2 is true. D. Both the statements are true. Evaluate the powers and jurisdiction of administrative tribunals. The correct option is D. Both statements are correct. Statement 1 is true. Article 323A allows for joint administrative tribunals with the same jurisdiction. Statement 2 is also true. The Act confers upon tribunals the same jurisdiction and powers as a High Court with respect to contempt of itself, and references to High Court in the Contempt of Courts Act 1971 are construed to include such tribunals. Thus, both statements are true. Now for question number 91. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A. A money bill can be introduced only in the House of the People, Lok Sabha, and not in the Council of States, Rajya Sabha. Reason R. The Council of States may only make recommendations on a money bill within 14 days, but the House of the People may accept or reject them, and in either case, the bill is deemed to be passed. In the context of the above assertion and reason, under Article 109 of the Constitution of India, which one of the following is correct? A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. This question concerns the special procedure for money bills in Parliament. The correct answer is A. Assertion A is correct as per Article 109, Clause 1. Reason R is also correct, accurately describing the limited role of the Rajya Sabha as laid out in the subsequent clauses. The reason explains the practical effect of the primacy given to the Lok Sabha in financial matters, which is why money bills must originate there. Therefore, R is the correct explanation for A. Let's examine question number 92. A company registered under the Companies Act 2013 is required to file a declaration of commencement of business before starting operations. The directors ignore this obligation and the firm commences business activities without filing the declaration. How much penalty can be imposed on the company by the registrar concerned for such non-compliance? A. Rupees 25,000. B. Rupees 50,000. C. Rupees 75,000. D. Rupees 1 lakh. This is a question about a specific penalty under the Companies Act. The correct answer is B. The penalty for this default is prescribed in the Act. The requirement to file a declaration is under Section 10A of the Companies Act 2013. If a company contravenes this, the section itself provides that the company shall be liable to a penalty of Rs 50,000. Moving on to question number 93. If multiple offences carry different punishments, but it is unclear which one has been committed, how does Section 72 of the Indian Penal Code ensure proportional justice? A. By imposing punishment for the offence with the lowest prescribed term. B. By applying punishment equal to the average of all possible offences. C. By leaving the choice of punishment to the prosecuting authority. D. By suspending the punishment until further clarification is made. What is the rule of sentencing when there is doubt about which of several offences has been committed? The correct option is A. The principle is a rule of leniency. Section 72 of the IPC, corresponding to Section 10 of the BNS, addresses this. It provides that where it is doubtful which of several offences a person is guilty of, the offender shall be punished for the offence for which the lowest punishment is provided. This gives the accused the benefit of the doubt in sentencing. Let's proceed to question number 94. Mr. X owns a bakery where he employs Y, a 16-year-old adolescent. At first, X gives Y every Sunday off as his weekly holiday. After 2 months, X decides to change the weekly holiday to Wednesday and pastes a notice about this change on the bakery wall. According to the Child and Adolescent Labour Prohibition and Regulation Act 1986, this change is A. Valid since employees can change the holidays anytime by giving notice. B. Invalid since weekly holidays cannot be altered before completion of at least 3 months. C. Valid since the adolescent is given a full day of rest every week. D. Invalid only if the notice is not displayed in the establishment. This question tests the specific rules regarding working conditions for adolescent labor. The correct answer is B. The Act provides specific protections. Section 8 of the Child and Adolescent Labour Prohibition and Regulation Act 1986 states that the weekly holiday for an adolescent shall not be altered more than once in 3 months. Since Mr. X changed the holiday after only 2 months, his action is a contravention of the Act and is invalid. Let's take up question number 95. Which person would not be treated as a consumer under the definition of the Consumer Protection Act 2019? A person who purchases refrigerator on installments for home use, a person who buys a television partly paid and partly promised for family use, a person who purchases goods for the purpose of resale or for any commercial purpose, or a person who uses furniture bought by a relative with the latter's consent. The correct answer is C. The definition of a consumer in Section 2(7) is broad, but it contains a crucial exclusion. It specifically excludes any person who obtains goods for resale or for any commercial purpose. Options A, B, and D describe situations that fall within the definition of a consumer. Now, question number 96. Given below are two statements, one labeled as assertion A and the other labeled as reason R. Assertion A. The President of India has the power to grant pardons, reprieves, respites, or remissions of punishment, or to suspend, remit, or commute the sentence of any person convicted of an offence in cases where the punishment is by a court-martial or where the sentence is death. Reason R. This power under Article 72 overrides and completely nullifies the powers of the governor to commute or remit a death sentence under state law. In the context of the above assertion and reason, under Article 72 of the Constitution of India, which one of the following is correct? A. Both A and R are true, and R is the correct explanation of A. B. Both A and R are true, but R is not the correct explanation of A. C. A is true, but R is false. D. A is false, but R is true. This question examines the President's pardoning power and its relationship with the Governor's power to commute or remit a death sentence under state law. The correct option is C. Let's analyze this. Assertion A is true. It accurately describes the President's pardoning powers under Article 72(1). Reason R, however, is false. Article 72(3) explicitly saves the Governor's power to commute a death sentence under any existing law. The President's power does not nullify the Governor's power. Therefore, the assertion is true, but the reason is false.
Let's turn to question number 97. In the following question, a statement is followed by two conclusions, 1 and 2. Statement: Under the Protection of Women from Domestic Violence Act 2005, a magistrate may issue a protection order to prevent the respondent from committing acts of domestic violence, contacting the aggrieved person, alienating assets or stridhan without permission, or causing harm to her dependents. Conclusions: 1. A protection order can cover not just physical violence, but also financial and emotional aspects of domestic violence. 2. The magistrate has wide powers to restrict the respondent's conduct to safeguard the aggrieved person and her dependents. In the context of the above statement and conclusions under the Protection of Women from Domestic Violence Act 2005, which one of the following is correct? A. Only conclusion 1 follows. B. Only conclusion 2 follows. C. Both conclusions 1 and 2 follows. D. Neither conclusion 1 nor 2 follows. Evaluate the scope and purpose of a protection order based on the given statement. The correct answer is C. The statement itself, based on Section 18 of the Act, provides the basis for both conclusions. Conclusion 1 is correct because prohibiting contact relates to emotional aspects and prohibiting alienation of assets relates to financial aspects. Conclusion 2 is also correct. The ability to issue such a wide range of prohibitions clearly indicates the magistrate is vested with extensive powers to safeguard the aggrieved person and her dependents. Therefore, both conclusions follow. Now let's address question number 98. According to the Motor Vehicles Act 1988, which factor determines the jurisdiction of the licensing authority in applying for a driving license? A. The place where the applicant has family ancestral property. B. The place where the applicant has held a bank account for more than a year. C. The place where the applicant votes in local body elections. D. The place where the applicant ordinarily resides or carries on business. What is the legal basis for choosing the location to apply for a driving license? The correct answer is D. The jurisdictional basis is provided in Section 9(1) of the Motor Vehicles Act 1988. It states that an application can be made to the licensing authority in the state where the applicant ordinarily resides or carries on business,
or where the relevant driving school is located. This provides a clear practical link. Here is question number 99. If a convict sentenced to life imprisonment is being considered for remission fractions under Section 57 of the Indian Penal Code, which equivalent term of years is applied by the court? A. 10 years of imprisonment. B. 20 years of imprisonment. C. 40 years of imprisonment. D. 50 years of imprisonment. What is the statutory equivalent of a life sentence for calculation purposes? The correct option is B. This is a specific legal fiction created for calculation. Section 57 of the IPC states that in calculating fractions of terms of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. This does not mean a life sentence is only 20 years but is used for calculations. The same provision is in Section 6 of the BNS 2023.
And finally, let's move to question number 100. According to the Payment of Gratuity Act 1972, under what circumstance is the completion of 5 years of continuous service not mandatory for payment of gratuity to an employee by his employer? A. Voluntary resignation from the post by the employee. B. Dismissal of the employee due to misconduct at work. C. Death or disablement of the employee due to accident or disease. D. Transfer of the employee to another department within the same organization. What is the major exception to the 5-year service rule for gratuity eligibility? The correct answer is C. While the general rule for gratuity requires 5 years of continuous service, there is a significant exception. The proviso to Section 4(1) of the Payment of Gratuity Act states that the completion of 5 years is not necessary where termination of employment is due to the death or disablement of the employee. In such events, gratuity is payable regardless of the length of service. This concludes our detailed review of the question paper. Thank you.